What happens when a Colorado landlord doesn't return a security deposit? When the landlord doesn't return the security deposit within 1 month, or whatever deadline is specified in the lease, the landlord loses all right to withhold any portion of the security deposit. To get the security deposit back, though, the tenant might have to send the landlord a notice that demands the return of the security deposit in full and informs the landlord that if the deposit isn't returned, the tenant will sue the landlord. A tenant can sue a landlord who willfully withholds the security deposit past the due date for treble, 3 times the amount of the portion wrongfully withheld. The landlord will also be responsible for the tenant's attorney's fees and court costs. In order to sue, the tenant must first give the landlord written notice of their intent to file a lawsuit at least 7 days before filing. The intent of this notice is to give the landlord one last chance to return the wrongfully withheld amount before having to go to court. A landlord willfully withholds the security deposit if they receive the notice and still don't return the security deposit. The statute doesn't clarify how notice should be sent. Tenants should read their lease to see what it says about providing notice to the landlord. Some leases allow notice by email, but most require notices to be sent by U.S. mail. Tenants should closely follow the guidelines in their lease to send the notice. But if the lease doesn't mention how to give notice, the tenant should send the notice by registered mail, return receipt requested, and keep a copy of the receipt to prove that the notice was sent and received. Another possible way is to personally deliver to or even serve the landlord with the notice. No matter how you deliver the notice, be sure to document it so you can show the judge. For most Colorado tenants, it's easiest to sue their landlord in small claims court.